This is the plaintiff, Robert Lindgren. He says he rented an apartment from the defendant, and as it turns out, that guy's a weasel. He's withholding his security for no valid reason, thinking he's the type who'll just walk away. But he doesn't walk away from money, and is suing this louse for every penny of the $1,875 he's owed. This is the defendant, Rodman Williams. He says the plaintiff was his tenant for 5.5 years, and the guy just up and moved out without ever giving him a move-out date. He severely damaged his home in the time he lived there. He had to spend all kinds of money fixing the place back up. And if he thinks he's getting any of his security back, he's mistaken, because the judge will side with him today, no doubt. He's accused of taking advantage of a tenant.
All parties, please use your hands.
Welcome back to the People's Court. Next case in the docket. The plaintiff says the defendant is a weasel landlord who stole his security, but the defendant says the plaintiff bolted without notice. It's the case of Pop Goes the Landlord.
Thank you, Douglas.
You're welcome in.
Robert Lindgren, you are suing your former landlord, Rodman Williams, for $1,875, double your security deposit, because according to you and the state laws, you say that you're entitled to double your security deposit for him wrongfully withholding it. Tell me what's going on.
Well, I moved out January 31st. Upon me leaving, I gave him a piece of paper, my name.
You moved in January 31st of what year?
I moved out on January.
Moved out January 31st. Were you on a lease or a month-to-month?
I moved in 2012. I was 1 year until that point. Then it was month-to-month afterwards.
So for the remaining 4 years that you were there, it was month-to-month?
Right.
Okay. So you moved out January 31st, but I'm going to need you to rewind to when you told him that you were going to move out.
All right. I told him on January 10th. I verbally told him, and I asked him, is it okay if I move out at the end of the month because I have a job as a manager at a complex? He said, sure, no problem. If he wanted the full 30 days, I would have stayed another extra month or half a month so I could do it all legitimately. But he said there was no problem with that.
Okay, watch this. Are you ready? Did that happen?
Not precisely, Your Honor.
Did he called you and he told you I'm moving, you know, and is it okay if I leave a month early?
Well, he spoke to me and said he was leaving.
Okay.
And he didn't specify a date.
At all?
At all.
Okay.
So he was there about 2 weeks, 2.5 weeks, and the next thing I know, a truck pulled into the driveway. I believe it was his two brothers helped him move the
Do you live there
out.
too?
Pardon me?
Do you live there also?
I live downstairs, Your Honor.
Downstairs. So according to you then, your first time that you realize that he's leaving right now is on the day he's moving.
I'm sorry?
Because he didn't tell you it will be the end of the month.
No.
Okay. Now, why didn't you send notice of your intent to leave in writing? You're a month-to-month tenant,
right,
and you have to give him notice. So why didn't you just send the notice?
Well, what it is, I saw him in the driveway. So I spoke to him face to face, and I told him the exact time I'm leaving.
Right, but you see how that's going, right? Because that's not working out for you. So in your lease, it actually says that even if you're holed over from month to month, that there's a 30-day notice requirement. It actually says that.
Correct.
So it's your lease. I assume you've read it. Why didn't you give the full 30-day notice?
I would have, but since we were on a friendly basis, I kind of did it more informally.
Not a good idea.
I know,
then he leaves, and then you do not return the security deposit. But you do not send him a letter, as the law in New Jersey requires, within the 30 days to tell him why you're not returning his security deposit. So you don't send the letter, and then you file a lawsuit.
Right.
But curiously, you don't request the security deposit back either.
Right.
Okay.
Right. The reason why, I knew he was going to give me a hard time.
And you felt he was going to give you a hard time. Why?
Because
according to you, he gave you sweet permission to go ahead and leave.
Right, right.
So he gave you his blessing. So then why did you think you were going to have a hard time?
Because we had many confrontations during that time.
Okay.
And
which would make it less likely he'd pay out of his pocket for the next month when he only had part of the month to rent it out, right? Makes it less likely if you've had all these confrontations. All right, now, according to you, how much is the rent?
$675.
$675. Is that accurate?
Yes.
Okay. So you have more than the $675, and your claim to that is what?
The damage done to my apartment was so extensive.
Okay. So just as New Jersey law allows the plaintiff to sue for double the amount wrongfully withheld, you have a right to say why you withheld it, even if you botched it on the letter, but you shouldn't botch it on the letter, okay? So tell me what was damaged.
First thing I had observed when I entered the apartment was the tile in the bathroom on the bathtub shower had fallen off the wall.
Okay.
And I was never notified of any such occurrence. And then I noticed that the rug was severely stained.
Okay, do you have pictures of the rug?
Yes, I do, Your Honor.
Okay, because the tiles, how did the tiles come down?
I was cleaning it, and they all fell in because...
Yeah, I don't believe that a tenant would end up being, unless you're going to tell me that he bashed something into it, that the tiles were broken, that there was an accident. You're talking about tiles falling off of a thing, that's not the tenant's problem. But let's talk about the rug, because really, all you got to account for is another $200 and something, $300. So what happened with the rug? Show me the pictures.
There were some severe stains on the rugs, and I had brought them to his attention before, and he said, "Oh, my sister has a cleaning business, and she'll take care of cleaning the rugs."
Did he have a pet there? Or no, it was just traffic stains? What was it?
He had a couple of birds in a plastic box.
All right, let me see the pictures. What's your response to the rug?
Okay, the carpet was like that when I moved in. Now, when I moved in back in 2012, my best friend was already living there for 3 years. All right, it was stained pretty bad. You can tell it's a very, very old carpet. When I moved in, I told my friend and I told Mr. Williams, don't worry about cleaning up, it's fine. Now, last summer, he mentioned to me he wanted to replace the rugs, and I told him, don't do it on my account because I don't really care that much about it.
Do you have any written proof of that, like emails or texts or anything like that?
No, I do not.
Do you have pictures of the way you rented it to him to prove to me that it wasn't like this?
No, Your Honor, I did not.
Do you have an email or an affidavit from your friend to prove that it was like this?
No. I mean, the carpet's at least 7 years old.
What else? When was that rug purchased? Do you have that evidence?
It was purchased before I moved in 1989.
Okay, next. Next.
So, who's a bigger offender? Tenants who damage apartments or landlords who wrongly withhold security?
Definitely the tenants. They shouldn't be damaging stuff.
But do they damage it typically? Do tenants disrespect landlord's property? Typically.
No.
Yeah, I kind of think you're right. What do you say?
I say tenants as well. I think that, when you don't own the home, you don't care as much about it, and then they end up damaging everything and breaking things.
Anybody think the landlord's more of an offender?
They should have a good deposit so they can pay for the stuff that the tenants broke.
I was just going to say that. Yeah. Going inside the courtroom.
There were terrible nicotine stains all over the walls, and I sent him a certified letter stating that the lease said there was no smoking in the apartment.
Are you a smoker?
Oh, yeah.
Do you smoke in the apartment?
Yeah, we agreed to that.
Does the lease say you can't smoke in the apartment?
It does. It says two things, that he said it was okay. Now I know it should have been done in written. Number one, I am a smoker.
Does the lease say that he says it's okay?
No.
Right, the lease says the opposite of what you're saying, right?
What he says, no smoking, he says smoking's okay. Also, I said...
Oh, you got it. You can't have a written recording of an agreement between people and go, yeah, we both winked, so everything's okay, and then complain that it comes back to bite you if, in fact, that happened.
Right.
But most landlords really don't want you to smoke in the house because do you have pictures of when he took down his pictures, what the walls look like?
Yes,
yeah,
ma'am.
hand them over.
I realize now.
Yeah, okay.
That I should have had written.
Yeah, let me just tell oh, look at that. Any tenant within the sound of my voice, if there is something in your lease that you cannot do, and you want to be able to do it, and you ask your landlord, you make sure your landlord writes you an email or signs something, an addendum to the lease, or if an addendum is beyond your grasp, just have them send you a text and save it, or an email that says, yes, you can have a pit bull, because when you come into my courtroom later and you look me in the eye and say, I know that the lease says that I can't have a pit bull, but I got to tell you, he told me you can have a pit bull. I'm not going to believe you. I don't even want to know about any more damage. I don't need to know about any more damage. I find that none of the security deposit has been wrongfully withheld, and I'm ruling in favor of the defendant.
Wow.
Well, it was not a good day for the plaintiff.
Can you believe it?
What do you mean you can't believe it?
I can't believe it because of the dishonesty that took place, and I wasn't able to state everything I wanted to.
Well, you know, the judge goes by evidence.
I know, I know.
It's got to be on paper. She's
Yeah,
got to be
I know.
able to see it.
Right, I understand now. At that point, I didn't. When I moved in, I didn't know it.
Yeah, well, you've learned.
Yes, yes, I have.
Better late than never, right?
Correct, yes.
Sorry about that.
All right, thank you
Okay.
very much.
Yep. Mr. Williams, did you tell him he could smoke?
No.
I didn't think so, yeah.
I have a registered letter in my files that I sent to him specifically telling him he cannot smoke besides the tenants of the lease.
Yeah. Should have brought it out, although you didn't need it.
No, I
Really
didn't need it.
Yeah, no kidding. Well, congratulations, okay?
Thank you.
You wear your Vietnam pin?
Yes.
You keep that on all the time? Proud
It's-
of it.
Yes.
Very good for you. Thank you
Okay.
for your service.
Okay. You're very welcome.
Okie dokes.
Pleasure meeting you.
Harvey?
Okay, Doug, look, if there is any deviation from the lease, if you do anything that the lease specifically says you're not allowed to do, even if the landlord says you can do it, get it in writing or else you are asking for a lawsuit. And that will do it for this case. Litigants for the next case on the way into the courtroom right now.